I do not wish to be represented by a attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barricade was an unlawful arrest.
What you're witnessing right now is the opening move in a very familiar courtroom strategy, one that sounds powerful but rarely holds up under legal scrutiny. The defendant is framing his argument around sovereignty, attempting to separate himself from the authority of the court. But here, the tension: courts don't operate on personal interpretations of freedom, they operate on established law and jurisdiction. And already you can feel the disconnect building. The judge is grounded in procedure while the defendant is leaning into ideology. That gap is where things begin to unravel.
All right, and that's what I'm going to call now, because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBus, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr.?
This moment may seem small, but it's actually critical. The defendant is questioning whether this is a court of record, trying to establish a technical weakness in the system. But the judge calmly shuts that down because recording exists, transcription exists, and legally that satisfies the requirement. This is where many defendants lose momentum. They focus on procedural technicalities hoping to destabilize the court, but instead they reveal a misunderstanding of how modern court systems function. And the judge, completely unfazed.
One moment, Your Honor. Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
And Your Honor, I would note that pursuant to the information filed with the court in August, this case does appear to include 3 counts, 2 Class Bs, and an unclassified non-person misdemeanor. While it would appear that in this particular instance, subsection 2, pursuant to KSA 216602, quote, for purposes of sentencing, the following classes of misdemeanors and the punishment and the terms of confinement associated for each class are established. Class B, the sentence for which shall be a definite term of confinement in the county jail, which shall be fixed by the court and shall not exceed 6 months. So, given that, my understanding is that neither a plea nor sentencing recommendations have been submitted to the court in this matter, it would appear that at least the issue raised by standby counsel is somewhat academic.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities, for the people itself. I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, um, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you, and do you not want to have his legal assistance to let him represent you?
Now things take a sharper turn. This isn't just about beliefs anymore, this is about rights versus procedure. The debate over a jury trial exposes something deeper. The defendant doesn't fully grasp how to assert his rights within the legal framework. Meanwhile, the attorneys and judge are speaking in precise legal language, statutes, case law, constitutional rights. This creates a dangerous imbalance, because in court it's not enough to have rights, you have to know exactly how to exercise them. And right now, that gap is widening fast.
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barricade was an unlawful arrest.
All right,
for
well, we're not going on
22-2401.
We're not going down that path right now, sir. We're not going down that path right now. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pre-trial will be September 30th, 2024. Do you have any objections to that?
No objections. Let me write those dates down. You said September what?
The pre-trial is September 30th, 2024 at 9 a.m. And the jury trial starts at 9 a.m. October 2nd and 3rd.
Both of those dates?
Both of those dates.
Okay. I would like to point out that the bond and bail I made on this arrest is an unlawful bond, considering that the arrest was unlawful itself.
Looks like Judge Crum set your bond on August 18, 2023 at $2,500 cash or surety, and that will be maintained so long as, sir, you appear at every date and time you're required. Anything else, Mr. Regier, we need to take up on this matter?
Your Honor, if the court is granting the defendant's request for continuance, I respectfully have it noted for the record that this case at the next hearing will be over a year in age, as I understand it. So the state is not in favor of this continuance. So I would respectfully have that noted. Additionally, my understanding is that a motion in limine was filed by my office, and if the court is setting this matter for both pretrial and jury trial, I would respectfully reserve my rights pursuant to the state and have the motion in limine be addressed at the pretrial hearing.
That the objection of the state to the continuance is noted, and yeah, we can take the motion in limine up.
Your Honor, if I may be heard briefly.
Yes, Mr. Patterson, please.
The motion that counsel is talking about was emailed to me. I'm not the attorney of record, so I have not accepted service. I sent an email back to counsel, and I did provide Mr. DeBus's address that I had seen in the court system that they can directly mail that to, and I've just asked that that be mailed to Mr. DeBus for service.
And Your Honor, I am showing in my file an affidavit of service by first class mail, and which would appear to include a mailing date of at the end of last week.
All right. Very well then. And if there's nothing further, did you get that, Mr. DeBuse? Did you get the copy of the motion he's in reference to?
To what mailing address did you send it to, Mr. Revere?
Well, just tell me if you got it or not, sir. Did you?
No, I did not.
Okay. All right.
And Your Honor, one last thing, I did email to court counsel the copy of the case law about constitutional right to a jury trial.
Thank you, Mr. Patterson. I appreciate that. And Mr. Regier, he wants to know what you sent that to.
I'm afraid I do not understand the court's inquiry.
He wanted to know what the defendant asked, what address you mailed the motion to.
Your Honor, the affidavit of service I have in the file appears to be at an Andover, Kansas address.
Okay. Are you still in Andover, sir?
I'm in Wichita.
All right. Well, you have to keep the court informed of your address, or you're going to maybe miss more important documents. So, can you send your current address to Mr. Patterson and Mr. Regier in the chat here without having to say it?
This is the turning point. The judge is no longer just listening, he's warning. Representing yourself in court isn't just a right, it's a responsibility. And what we're seeing is the reality of that decision. The defendant wants full control, but the moment legal complexity appears, he leans on standby counsel. That contradiction weakens his position. The courtroom rewards clarity, preparation, and structure, not resistance without strategy. And the judge is making it clear, this path only gets harder from here.
Live over the internet?
I'm not for sure the address is going
I'm sending in the mailing address now.
Okay.
Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. I keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas. Okay, so that takes care of Mr. DeBuse's case. You are excused, sir.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Jabbar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in the first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Jabbar Grayson on the Zoom? Say something if you're here at this time.
Yes, Your Honor. Jabbar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction. You're not sitting into the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't have jurisdiction?
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. What are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer. So go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is
Here where the consequences start to stack up. The request for delay might feel like a win, but in reality it's a double-edged sword. The case drags on, the pressure builds, and the state gains more time to prepare. Meanwhile, procedural issues like incorrect address, missed filings, and service confusion begin to pile up. These aren't dramatic moments, but they are critical ones, because in court, cases are often lost not in one big collapse, but in a series of small, avoidable mistakes.
Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. So that's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that the defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss and will answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic. I guess is a some type of traffic ticket. I started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that, and I do understand the default judgment. What do you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's action being taken against me as we speak. This is a current case, and 36 district court have no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiffs, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed the state of action upon which the court could grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you could formulate case law or some type of law that supports your cause of action.
Across all 3 hearings, the pattern is unmistakable. Each defendant challenges the system by rejecting its authority, questioning jurisdiction, invoking sovereignty, and asserting personal interpretations of constitutional rights. But the courts respond the same way every time, with procedure, structure, and established law. In Kansas, the case is delayed but not dismissed. In Michigan civil court, the claim fails due to lack of legal foundation. And in the criminal case, repeated objections without proper filings change nothing. The key takeaway: in court, belief is not enough, only legally recognized arguments move the case forward, and when those are missing, outcomes become predictable. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.